welcome to this SIG web series. Insol India has taken this initiative to look into it, and all these experts who have on their fingertips on these situations that we are passing through despite COVID situations. I saw she's just telling me that he just came out of a meeting where he was doing matter with others, with the maybe lawyers or whoever they were, the solicitors on record. But each one of us have now seen something new. How the insolvency and how the situations of distressed assets, how the NPS are going to take effect is a new situation that we are witnessing. And I thought all these experts' views on it, how will they tell us how to go way forward? They lay down the path for us. And may I request you to please start your webinar. And thank you all of you and welcome to this Insol India's webinar today.
Thank you, Mr. Chandihok. I am Dhananjay Kumar. I'm a partner at Cyril Amarchand Mangaldas. I'll be moderating this webinar. I've got a very distinguished panel here to discuss this topic. I've got Mr. Padma Kumar M. Nair, who's the Chief Manager of Stressed Asset Resolution Group at the State Bank of India. I've got Mr. Akash Suri, who is Group President and Head Asset Reconstruction and Management at Yes Bank. And I've got Ashish Chaucharia, who's a partner and head of restructuring services at Grant Thornton, India, and is also an insolvency professional. So welcome, gentlemen. Thank you for giving the time for this webinar. The model we are going to follow is as moderator, I'm happy to pose questions to each of you. It's 4:03 now. We will spend next 55 minutes or so in discussion among ourselves. After that, we will use the Q&A box of this app for a Q&A from the crowd for last 15 to 20 minutes. I'm very happy to be here and discuss this topic with all of you. Thank you. Why don't I start with Mr. Nair and ask him straight away as a lead bank in many cases, as a large Indian bank, what do you expect when you go to pick an IRP, when you look to file an insolvency proceeding against a debtor who's in default? What is that you look for, and how do you run this process?
Right. Thank you, Dhananjay, and thank you, Insol India, for inviting me for this program. One caveat, though, whatever I'm going to speak here may not necessarily be view of the State Bank of India. Having said that, the selection of a resolution professional is a very critical aspect when a company is taken into the IBC. And in State Bank of India and in many other banks, because we form the COC and then we sit around and try to select the best candidate. What we look into is he should be empaneled in one of the banks in the consortium. Besides that, he should have a domain knowledge, and particularly domain knowledge on the industry in which the unit is functioning. And apart from that, we also have the experience of the banks on this particular resolution professional. And we also count on the resources he has to support him as he progresses along. And we also look into the number of resolutions he has done in the past. So it's a fair combination of all these factors that go into it, and the technical evaluation is done. And that technical evaluation, one critical aspect of it is the determination of the RP's, potential RP's capacity to determine the financial health of the corporate debtor to arrive at a suitable strategy for a quick resolution. We have 180 days and thereafter maybe some extension about 90 days, but the core of the entire process is quick resolution. So what we will look around is the capacity of the RP to arrive at a very quick resolution. And that is actually very critical. And then another important aspect which we look into him is the capacity of the RP to ensure continuation of essential services of the corporate debtor, because you have to take the corporate debtor as going concern. So these two are very critical aspects which we look into it. And then finally, the financial bits are called for. But at the end of the day, it could be an 80-20 model, could be a 70-30 model, it could even be a 60-40 model. But you cannot ignore the fact that these critical aspects which I have already enunciated are the ones which will go to determine who will win or who will not. Over to you then.
Ashish, if I can come to you as an insolvency professional, I'm sure you would have participated in many of these processes by SBI or other banks. So how do you respond to this, and what has your experience been?
Certainly, Dhananjay. Thank you. And thank you, Mr. Chandiok. Thank you to Insol India for giving me this opportunity. I'm very glad to be here and share my thoughts and views on this important subject. So Dhananjay, when we get these RFPs, and there are many of them that we get, as you can imagine, because many of the banks have now started this empanelment process. I mean, there are different case laws around this, which we are not going to get into any detail for, but we get invited for these, proposals to be submitted for, acting as RPs. I think when we receive these, we always try to showcase, as Mr. Nair also mentioned, that what are the strengths and experience we have as an organization, along with the RP who's going to support the RP. Because of course, the RP is the person who's going to be individually responsible and appointed for this. However, it's very well recognized even in the code that it's not an individual who's going to carry out the entire work. There's going to be the support services, the support firm. So the industry experience, the handling of matters of large cases, multi-locational, that when we are able to represent to the banks, that's where I think that makes it easier for them to sort of make the shortlist for their selection process. But we do often also find that at times it boils down to an L1 situation, though not ideal, but it does boil down to that often, while there is supposed to be a quality and value sort of weightages. But sometimes it's difficult. I do understand, when there are public sector banks, the easiest way to score is on the fee numbers and not always on the quality. It's difficult to score on the quality. I find that is why sometimes I've seen that happening, but mostly I would say that, the selection of IPs, especially for, the large and, where the stakes are very high, I think the banks have done a great job in, picking in most cases.
That's great. So once IRP is appointed, we all know in the IBC process, the first thing that IRP will have to do is take control of the assets, take actions to preserve and protect. So Akash, if I can come to you and ask you as a bank, it's easy to say preserve and protect the asset, but what do you expect an IRP, an insolvency professional, to do once they are appointed by the NCLT?
Sure. So thank you so much, Sri Dhananjay and Insol team for giving this platform for all of us to discuss our views. So before I start on this question, on a lighter note, to Ashish, generally when we decide on IRP, we first finalize on the quality and then we haggle with you on the cost. So,
sure.
So that's a secret. But like you said, Dhananjay, I think it's well recognized that the most important sort of role of RP and the team is to ensure the preservation of the value, right? Because end of the day, RP is the custodian of the corporate debtor, and its primary role is to work the process through and then finally hand over the company, say to the right suitor. And I think in that context, while there is no cookie cutter answer to what is required to be done to ensure that value is done, each case will be very different. But I think it's a couple of very important tools which are there as part of the Act is naturally the concept of interim financing. And I think capability and timely thought process naturally in consultation with the COC to raise the right amount of money and to write have, right? And I think so somewhere it's also that banks or the existing say creditors are also relatively reluctant in participating, right? And so generally we look at a third party to bring in the money, and it may in some sense also be linked with that end of the day that incremental financing, while is super senior, it is still to the same borrower and has say classification and say provisioning impact. And I think somewhere say one thought that we have to all say delve on is that say whether the regulation can also act in tandem, and the interim financing, say given its super secured structure, may not necessarily be classified as NPA, has a repayment which is more linked with the resolution of the company rather than say monthly servicing which is required. So interim financing in that regard is a very important tool. Second, like in all ongoing companies, say key thing that a RP has to look at is to say segregate the core of the business and non-core of the business. And I think in all businesses there are parts which say where you put more money, it is accretive, and part which is say better monetized, and the act very well allows that. And I think in the collective wisdom, how do we sort of say monetize, sell some assets which are non-core, and rightfully deploy those resources to say preserve and enhance the value is, I think, it's a couple of say key components. But I think it's easier said than say job done. It's a very tough job in the hands of RP, and as lenders, we very well recognize.
So you raise an important point, Ashish. If I can come to you and ask you, how do you handle a situation where you don't have cash flows? How do you do preservation protection in that kind of a situation? What has your experience been? What are the steps that you take to sort of achieve the duty that has been imposed on you by the process?
So Dhananjay, you have touched a very raw nerve for many NRPs who face this situation. And while the law requires that protect and preserve the value of the assets, but law doesn't say that the RP has to dip into his own pockets, provided that even has those resources to be able to do that. The main stakeholders who are impacted by this are the lenders. And I have seen in situations where, obviously we are talking about a situation where there are no cash flows and no steady cash available in the business. So the lenders being the largest stakeholders, and also the financial creditors and the COC, I think, if the path was made slightly easier for them, I think they do understand the need for, spending small money to protect the bigger cause. It's not that they don't, but I think there are some restrictive covenants, as Akash was mentioning, about, the provisioning norms, etc., which kick in. And there are some banks, I think, have internal guidelines about, funding an NPA account. Obviously, the account is NPA if it has gone into IBC, but we have, in fact, have gone into a situation as well where we had to go to NCLT to seek directions. And despite that, there were few lenders who were unable to meet because they said we are under the PCA framework of RBI and we are not able to, provide. So while I do appreciate and understand the constraint which some of the lenders are working on, but at the same time, the poor RP, and here I'm speaking about, our community as a whole, they do face significant challenges of getting into an unknown situation and thrown right at the, middle of it, being responsible for it without any money to pay for security, insurance, basic employees, maintenance needs of the plant and machinery. It does become a huge challenge. We have, I think, one of the solutions which Akash alluded to with respect to finding some low-hanging fruit. So even where we have found some interim finance available from lenders who have provided as expense reimbursement, etc., we try to look out for some low-hanging fruit, which may be like some non-core assets, surplus assets, which can be monetized quickly, and try to generate some cash out of that. So it's a multiple sort of approach that we try to follow, Dhananjay, and uh, it's never one size fits all. It is always case to case. So, but it's the working between the lenders and the RP together, that working as a team, and fastest way to find a solution.
If you ask me, from my strict legal view, I don't think NCLT can force a lender to lend money for this. They have done it in case of sort of looking at the process in larger interests, etc. But I think it's very difficult for a court to force somebody to lend money to anyone,
I
whether it is
completely
NP
agree.
or not. So anyhow, but this is a real issue. I have, as in one of the objectives of IBC was to develop a sort of an interim finance market, and having given proper priority to this, that seemed to have not really gone in as much popularity or as much depth as people had expected it originally to be.
I
So in
wonder
any way,
why though, because
moving
there
on to
are
sort of the process.
sorry. I was saying I wonder why it is not developed, because there are, it is a priority funding. It is sits on top of the waterfall as part of CIRP. I think there are some sort of loose ends which needs to be tied up, and there was also some talk about creating a fund for this. While individual banks may be finding it difficult to directly fund into an interim finance, but something like a pool, if that's created for all these cases, I think that might be a solution for this. So I know various things are being considered, and we have also made some recommendations on that.
I think one of the issues can be the timeline. Uh, if you were if we were very clear about the timeline of 9 months or so, I think more lenders will come forward. But if you're staring down 2 or 3 years for a resolution, and only then get paid as an interim finance, that becomes an issue. Initially, there was that whole interest issue as well, but now some of that is resolved. Anyway, moving forward in the process, Mr. Nair, if I can come to you, one of the first things that the COC does as part of the process is decide the eligibility condition as to who the resolution applicant will be, what are the criteria, and then you expect the RP to sort of run the process to find you, as you said, a resolution plan as quickly as possible. So how do, if I can sort of ask you to put on your banker hat and ask you to tell me that how do you decide on this eligibility condition? What kind of thought process goes into it, and what are the expectations for running this process that you have from the RPs? That will be a useful insight.
Okay, thank you, Dhananjay. Before that, I wanted to, if you have to give a correct answer to this, you will have to see how the IBC process is actually different from the other processes, actually. So now if I can list out how it is different, and then I move on to how the RP is selected and all that. Let me start it this way. The IBC is different for the following reasons. One, it is the value maximization principle. IBC resolutions have proven to be much better recovery numbers for lenders compared to liquidation and DRT because of the underlying principle of resolution. Then the second point is that the credible threat of IBC process, wherein control of the corporate debtor may change hands, has changed the behavior of the promoters. You're able to hear me?
Yes, yes.
Yeah, it has changed the behavior of the promoters of the debtors. Third point is that management control is transferred to an independent resolution professional during CIRP period and to new owners upon implementation of the resolution plan, unlike other options where existing managements continue. Now, existing promoters can't take control back even after the resolution of debt due to Section 29A. Then IBC also provides for a time-bound resolution, else it moves into liquidation. Then moratorium during CIRP period enables provision of essential service and adequate protection necessary to maintain business continuity and value. So approved resolution is binding on all the stakeholders. That is very critical actually. From an investor perspective, all pre-CIRP period liabilities, whether financial, operational, or statutory, are all resolved, extinguished as part of the resolution. And therefore, diligence focus on forward-looking prospects rather than past period liabilities. So, and finally, IBC is purely creditor-driven approach, especially for financial creditors, as compared to a compromise and wherein process is run by management of the company and approval from 75% of the lenders is required. Now, since I have listed out all how it is different from a regular resolution process, now let me come to find out what are the eligibility conditions set by the Banks for Resolution Act. The banks generally require potential resolution applicants to provide requisite self-certifications of meeting all eligibility criteria. We cannot dive deep into it, but if they can give all those certifications and necessary documentary evidence, that is what we take it actually. Then banks would also generally require potential resolution applicants to provide all material information disclosures that would aid the RP and the COC to take a very informed decision on resolution applicants' credibility and antecedents. Now, there are some resolution applicants, if they are having publicly traded equity or debt instruments, would generally be required to disclose material information to their stakeholders. So I think we will conduct a preliminary research of such disclosures to see any material deviation from eligibility conditions. So now we have multiple options to determine all these things actually. So from what how the IBC is different from other processes to the selection, it will be a very comprehensive approach, which will cover all aspects of getting the best plan for the NOC. Yeah, over to you.
Okay, Akash, if I can bring you in as well on this question, how do you decide eligibility conditions for who should be, whether as basic as what should be the net worth of the company who can bid for this corporate debt? Should it be 100 crores? Should it be 500 crores? Should it be 1,000 crores? How much experience? How much sector expertise? How do you decide on some of this?
Sure. So again, like Sinar's mentioned, all of these matrices which are there, right? But essentially, what I would want to add is that there would be distinction by various corporate debtors, depending on the kind of industry they are in, right? So naturally, if in financial services there is something, then you would want to look at the capability of the RA, right, and which could be judged by AUM or his expertise or vintage of running similar businesses, right? So it is a lot to do with also the kind of business that we are dealing in. So broadly speaking, the criterias remain the same, but depending on the kind of business that we have on hand, it would change, right? So naturally, for a very large company, the net worth criteria needs to be significantly higher, right? And I think beyond all of this, there is a point with regard to 29A, the much talked about 29A, right? And the compliances with that. So just if I may, so it's a lot from a perspective of define. COC. So what needs to further be stressed on is the kind of engagement subsequently with his intention as well as their capability to look at the company and finally win the company, right? There are enough and more examples where we've seen, right, where there are RAs which have say, so to say, complied with all the conditions, all the eligibility conditions. They've gone all the way, say, won the company, but for various reasons, then the transaction still has not closed, right? So, so the point which I was wanting to stress on is, one is straight-jacketed sort of say criteria for us to get people through the door. But I think what is even more meaningful is the process and say diligence and focus that we follow in running the process to ascertain that the guy who's finally going to come through, say, his capability to get it done, right? Because end of the day, what matters is say how it gets closed.
Fair enough. Okay. Now I'm going to ask a difficult question to Mr. Nair. I'll come to Mr. Nair. Mr. Nair, so far the data that we have seen for IBC, it seems that the recovery for financial creditor is between 40 and 45%. Why is that? Why is the level of haircut so high in so far? And that data may also be affected by larger recovery in some of the larger cases. So the average number, if you remove the really large one, might even be lower. So why is that? What is the banker's perspective to this?
Yeah, Dhananjay, you have touched a very super raw nerve, actually, not just a raw nerve, but a very super raw nerve, actually. Now, at the end of the day, the recovery is completely, or if you can say the haircuts, is completely dependent on the sector and the cycle of that sector, actually. So now, if you look at some of the resolutions that have happened, actually, now, whether it is in the steel sector or in the telecom sector, now, if there is a upswing in the particular sector, at that point of time, the haircut would be substantially lower, meaning the resolution amount will be much higher than what you would normally get it when it is done. Now, that is one particular case. I mean, I will not take any examples, but that is how it is. But if you go to, let us say, asset-heavy industries, actually, generally asset-heavy industries gets good value, actually, because you have the physical assets to bank upon, actually. So any resolution applicant who is coming in, he sees physical assets and he can ascribe a particular value for those assets. Forget about the liquidation value and others which have been compiled by someone before the commencement or at the time of commencement of the CIP proceedings. He sees the asset, he ascribes a value to it, and he also can, looking into the sector and into the cycle of the sector, he can anticipate that this particular hard asset would be able to get me a good return going forward in the future. Now, you also have, like, where obsolescence is of critical importance. Now, if you go into such sectors, actually, the kind of haircuts which you will get will be very substantial. So there is no single, there is no thumb rule that, this can only be at 40% or 50%. It all depends upon the industry as well as the cycle, actually. And there are, say, for example, even in asset-heavy industries, like if you go to sugar industry, very heavy in terms of assets. But then if you actually go and then try to find a solution for a sugar industry company, it would be very, very challenging. So what I'm saying is that there is a dichotomy, or there is which so overall, what I'm saying is that actually all these things are completely depend upon the sector and on the cycle, and there is no hard and fast rule. So far, what we have observed is that the recovery or the resolutions under the CARP process has been pretty adequate, and the bankers are generally happy with it. So what happens is that if you take it out of context, then you could have a different conclusion. But nevertheless, overall, we are all pretty happy with the way the resolutions have gone until today.
I'm very happy to hear that. What Mr. Nair says is not the IBC process, it's not insolvency professional. I'm sure Ashish is very relieved by hearing this, and I will pull him into this now. So Ashish, what do you think is as an insolvency professional, as a seasoned restructuring professional, why do you think the recovery levels are this at this level? Is it, as Mr. Nair says, just a function of industry, or do you think there are some other factors at play as well?
So yeah, thanks, Ananjay, and I certainly am very pleased to hear Mr. Nair's comment, not to be taken out of context. Every case is different. We do understand that, but actually, my thoughts on this are two things I would say here. Really, that if you take out some of the big 3-4 cases that have got resolved in the last 3 years, if you take a 3-year history of IBC, really, I'm taking from the point when the Big 12 started, the June 2017. If you count from there, in 3 years, and you take out the big 3-4 cases that have happened, got resolved, probably your recoveries are even lower, substantially lower than what this 40-45% average that we're talking about. But it's good to see that overall we have 40-45%. But the recovery being lower or at 40%, I think there's a reason for that. And the reason for that is because the cases that are going through the system in the beginning are those old toxic cases where there is a huge amount of piled up debt. The companies, many of these companies were already struggling long before IBC, they were filed into IBC. Plus, of course, the industry factors which Mr. Nair mentioned, absolutely valid. I mean, an EPC company, what recoveries you would expect there vis-a-vis, a steel maker with, with hard assets on the ground will be substantially different. But I feel that, once this whole wave of toxic companies, is kind of gone through, the purpose of IBC is more for finding quick restructuring, and this will be facilitated hopefully with with the introduction of pre-packs whenever that happens, where the value of the business is protected and sustainable debt is identified quickly, not just the upfront cash recoveries that are happening. So the real outcome of of IBC will be seen, I think, going forward. And I'll repeat one very often quoted statement by Dr. Sahu, that the real success of IBC is actually outside IBC, when cases are not really filed. So if you include all of that, your recoveries would actually probably be rating much higher than 40%. Sure. Back to you then.
Yeah, Akash, you have anything to add to what Mr. Nair and Ashish have already said?
No, I think just a couple of points, and I think Nair Sahab and Ashish has shared a lot of points on this. I think IBC, while very, very strong tool, right? It's not really as conducive per se for all kind of companies. So, for example, if you look at, so when we slice this data and we look at companies which are in EPC sector. Now, EPC sector, say to large extent, I have not seen any company which has gone into IBC come back alive from the process, right? It's unfortunately like that, right? And there is a reason for it, right? Because it just say those businesses are say strongly predicated on continuity of say business and financing of say bank guarantees, so on and so forth, which generally is extremely difficult while running a IBC process. Likewise, say the contracts and the issues with regard to that. So we have to segment this in some shape and form, draw learnings, and say there is a class of say companies which are say better resolved outside insolvency say process, and class of companies like Nair Sahab say mentioned, which are asset heavy, say which have a far better solution in IBC. Likewise, if you look at real estate, now say real estate with all the complication that all of us say know of, fundamentally in real estate there is nothing like a resolution, right? It is per se the business model is liquidation, right? You have to only construct and sell and liquidate and get the money back, right? So now if you very strictly look at a time bound, say 180 to 70 days process, it's very difficult to say find a solution there, right? And hence in some shape and form, if it is allowed that within IBC process you can keep funding interim finance, say get the inventory say completed, get it sold within the process and get the money back, it could be a very strong approach. But right now it is, say, barring a few cases here and there, it's not looked at it like that. So larger point I'm trying to make is, say naturally, say the statistics are very clouded, right? They are say coming from say 2-3 large say cases. There is a lot of say pile up of old cases, and hence it doesn't really say tell us the true picture yet.
No, I hear this, but let me ask you a slightly different question, Akash, staying with you. So you all say that, if it's asset heavy, business is good, all of that is there, then you will get a good recovery and there will be percentage will be higher. But compare this with the evaluation criteria that we are seeing in the market. The full focus is on upfront cash. If the focus of the process is on reviving the business and having it sustainable for next 20 years, 30 years, why is there so much focus on cash? Why are the recoveries not being pushed out?
No, I think it's a very good question, and I think say generally we're swayed with say some of the larger names and the large say cash recoveries. And I think cash recoveries, when you see, whenever someone is required to put cash on the table, right, no one has capability to have all the cash in their existing businesses, right? And that upfront cash needs to be financed. Unfortunately, except for 4 or 5 large names that we've seen, say well talked of, as we keep going down the road, right? So we go say lower in size, right? It's very difficult for, in the current context, for say resolution applicants more on the mid-market companies to have capability to raise cash, right? And even if they raise cash, there is a natural say balance between, if you want upfront cash, the recoveries have to be lower because whoever finances it will take a risk and the discounting factors would be significantly higher, right? Either that pot of money is going to come from the distress investors, which would naturally look at a much higher IRR, or from the banks or NBFCs, which would also price it right. So in my assessment, as we move forward for a lot of say companies, and we've seen especially on the mid-market side where there is a deferred cash, and I think it shouldn't be any taboo as long as you have the comfort say coming from the new say resolution applicant with proper checks and balances and due. I think deferring the cash is right approach to maximize value. So there is no harm in that.
Okay, Mr. Nair, your thoughts on this?
Yeah, so what happens is that by the time this the account gets into resolution phase in the COC, there could have been substantial erosion in asset values as well as, and the cash flows of the company itself would have got constrained actually. So now someone comes in, someone is going to put the money onto it actually. Now, at the end of the day, the upfront cash which is being put in, and from a banker's perspective, it's due to the net present value of the resolution plan probably goes up or comes down. So from an NPV point of view, a banker is pleased to see something which actually enhances its overall value. And it completely rules out any uncertainty with regard to recovery in future. And another important point is that it also increases the stake of the resolution applicant and his continued commitment to deploy resources to ensure a successful resolution plan. So that is very, very critical. Getting money is one thing, but at the end of the day, you have to get this going as a continuing business entity, and the economic activity has to sustain. That's the award principle of IBC. So when you get this money up front, we feel, as bankers, we feel that the resolution applicant is committed to it and he will drive this to its logical conclusion. And that is very, very critical. And from a banker's perspective, also another perspective is that, provision which is already made by the banks can be reversed to the extent of recovery made in the resolution plan. Straight away goes into the profit and loss of the bank. So now upfront cash, I mean, it's music to me. It benefits everyone. But the point over here is that applicants have the deep pockets and capacity to do that is anybody's guess. But from a banker's perspective, we love it.
Fair enough. But every judgment that we have seen, whether it's from the Supreme Court or NCLT, is all hinging on the fact that the COC does this ethical feasibility and viability analysis. That and the focus on upfront cash sounds a bit inconsistent to me. But anyway, I'll come to Ashish and ask him. Now I'll ask him to put on his restructuring advisor hat, and I'll ask him, when he advises the COC and COC asks him to submit a feasibility and viability report, how does he look at it? As in, how does he decide? How does he advise the COC? What kind of inputs go on this to decide whether this company is being revived in a sustainable fashion or not?
Yeah, thanks, Dhananjay. So I'll tell you, typically, the COCs, as you are very well aware, they would appoint an advisor for helping in the feasibility, viability of plans at the very last stage of the process, right? When the plans have been received, and assuming there's more than one plan, then they would expect to appoint, some advisor like me or someone else. We go in a little bit with our hands tied at the back, because if you see what has happened already by then is that the evaluation matrix of the plan has already been decided and announced, and every applicant, every bidder, he designs his plan to fit in best with the eval matrix. And why not? That's the right thing to do, because if the eval matrix gives a 40% weightage to upfront cash, he is automatically, in order to score the highest, assuming that there's more than one bidder involved, he will look for to score highest in that scoring, and he'll try to maximize the return there. So I think the discussions in the last 5-7 minutes, I think that's the most important, because if the bankers, if the COC members are more open to look at a longer term revival of the business where upfront cash is not the only criteria, then the plan has to be really vetted from the perspective of from the feasibility, viability in a longer term basis. And to be honest, it's no different from a credit appraisal that a bank does. Only thing is, the credit appraisal is now on the applicant's strength and credibility, not the company. So the applicant is saying how he's going to run the business, what are the backing he has. Typically, in my experience, what we have seen is that the ratio between qualitative to quantitative can be 30 to 70 in the scoring matrix, and within that, there is a very high weightage typically on the upfront cash. Our role comes in, those are quants, right? Quants are fairly easy to do if you can do basic Excel and NPV calculations. I think the stricter or the tougher bit is when you get into the qualitative evaluation. And that's where, to break it down, to make it more objective in nature, so that, all the lenders on the COC also feel comfortable in those outcome of that, and it achieves the right results. Because, qualitative, as you'll agree, that it's not all science. And I've got this esteemed panel of experienced bankers sitting here, so I'm not going to preach at all. They understand when you appraise a credit appraisal, it's not just about what you see on the paper. It's also about how you perceive. There is a perception involved. So we try to break it down into as smaller parts as possible. Try to break it into where you can put some objective methodology behind each of these scoring elements, and then come up with an outcome. If the evaluation matrix is designed in a way that it will promote a longer, let's say repayment option or a sustainable debt option, then certainly I think the expectation can be, you'll see that there may be more bidders, more RAs coming in, rather than the expectation of only, large upfront cash. But I completely agree with what Mr. Nair also said, that, getting cash back, where the accounts have moved into special situation group or SARG groups, that's the primary objective. So that's it's a little bit of a balancing act that needs to happen. Back to you, Dhananjay. You're on mute, I think.
Sorry. Yes. Next, I'll go to Akash. And one of the things that SR Steel judgment did, now we are talking about sustainability, reviving the business, etc. So towards that end, what SR Steel judgment said was liquidation value is the base for operational creditor, but they said COC will decide to pay specific operational creditor something extra to run the business as a going concern, what is important for survival of the business, etc. And COC has been given that discretion. So my question to you, Akash, is how have you seen this play out when you allocate something to operational creditor out of resolution plan? How is that decision made as a COC? What has been your experience?
So it's a very good question, Dhananjay, and I think say the thought process of the COC also naturally has say gone through a journey, right? To be honest, I think say to begin with, when IBC was in its early days, right? At that point in time, so naturally the distribution waterfall is fairly well defined, and I think at that point in time, the thought process and focus of the COC was a lot more to adhere to that, right? Which was say beneficial say naturally to the secured creditors, right? But as we moved with various say judgments, and also in a lot of cases say to take due and I would not say equal but equitable treatment of operational creditor, right? Say the RA also say plays a very important role, right? Because eventually say the existing say creditors may move out, but the RA would still have to continue to deal with the operational creditor. And I think say from that perspective, to have a say right treatment for them also is very important, right? And in that regard, in more say current cases, we've seen that say generally the COC is very considerate of the process of operational say creditors, and so generally the thought is to have a equitable view, and in a lot of cases we've taken a view that say their recovery should be equivalent to the debt stack which is there on the unsecured creditors, right? So it's gone through a journey, but like most things, there is no fixed rule again here, and I think so rightfully, as in the judgment, it's left to the right say judgment and wisdom of the COC.
Okay. So Ashish, as an insolvency professional, if I can ask you, how do you, if you have advised COC on this issue, how do you sort of decide on which operational creditor? Because you have the best insight as resolution professional as to who the critical vendors, etc. are. So how do you advise the COC on this issue?
So Dhananjay, on this, I think as Akash was saying, and I agree that the COC has traveled a long way since in the last 3 years. The initial expectation of the COC was most of the recovery or entire recovery should be largely as upfront cash and to the financial creditors only. But from there, it has come a long way, where there is a much more appreciation towards the fact that the smaller creditors or the operational creditors need to be addressed as well. There is a fiduciary role which the COC has played. I think some of the court rulings have also nudged towards that direction. So what I would do as an RP basically is to provide adequate information, firstly to the RAs, because ultimately the RA who is going to run the business in the future, he has to be aware and he has to understand that who are my critical suppliers to continue and sustain the business. And what we try to do is we nudge the RA to consider allocating in the plan itself that how he wants to, pay the operating creditors, because left to only the COC to decide would be a tad unfair, because the COC is not running that business. They are not going to be there in future to run that business. So it is the RA who needs to take a call, and for that they need information. So my role as an RP would be to then provide as much information as possible for them to make a judicious decision, because that's the only way, and to keep reminding COC that this is an important aspect that they should consider for the long-term sustainability, and especially going forward, as we discussed earlier, that if the plans are going to be on the basis of, not just an upfront cash, then it's very important that the business is sustainable. So if you don't pay those creditors, and moreover, I don't have statistics on this in front of me, but ultimately the operating creditors are also borrowers from the same banks elsewhere. So, they will be, you don't pay them, they will go bankrupt, and ultimately will come to the same set of banks indirectly. So, there are a lot of good reasons to take care of operating creditors, and this is, we have to keep reminding and, nudging in that direction. Back to you.
Yeah. I'm going to change track a little bit here, and I'm going to come to Mr. Nair and ask him what we have seen with IBC is also arrival of foreign stressed funds. We have seen ARCs becoming probably more active in resolution. So we are seeing, for lack of a better word, new faces around the table in resolution. So Mr. Nair, in your experience, how has this played out vis-a-vis Indian banks who have sort of so far been acting together? What has been your experience on this?
Right. There are two things. One, there are foreign creditors who sit in the COCs actually. And the second one is the stress funds and other funds which come in and bid as a resolution applicant. So first I will deal with the foreign creditors, See, the debt stack trading results actually in increased participation of these foreign creditors, and they bring in global perspective to the entire COC. Now, earlier, what used to happen is that a COC, which was a very limited affair, wherein only domestic issues were being discussed, suddenly enhances in its stature by discussing things which are truly global. And some of these creditors bring in some best practices which we have seen abroad and which we haven't seen till today. So that is pretty significant, actually. But there are some challenges as well. So like for some regulations as related to FEMA and RBI, or to be very honest, is not entirely consistent with the rules and regulations applicable to foreign creditors, which at sometimes frustrates the very object of IBC of being time-bound and flexible. So that's a major challenge which is there. This at times also limits the flexibility of a transaction structure from a resolution applicant's perspective. So now what happens is that I'll give you an example. The Chinese banks, I'm talking about the Chinese state-owned banks, they have significant exposure in some of the Indian corporates actually. Their statute does not permit these state-owned banks to hold equity in foreign companies actually. As a result of which, the resolution applicants is not able to propose an equity structure for the lenders. And secondly, an upfront payment to financial creditors, and very often to these financial creditors, if an upfront payment is suggested, then what happens is that they have to get the RBI approval to pay back these ECB lenders. And if they're not meeting the minimum average maturity period requirements, then it becomes a big challenge actually. Now, at the end of the day, this is again nothing but negotiations and the global best practices actually comes in, and eventually it all gets sorted out. So at the end of the day, the foreign creditors weigh in during negotiations with the foreign investors. So you have the foreign creditors and you have the foreign, assuming for a minute that there is a strategic fund which comes in. See, they are able to understand each other better. And actually, it may benefit not only both these parties, it could also benefit the domestic lenders as well, because the negotiation could be fast-paced, negotiation could prove more realistic, and foreign investors coming in would actually truly benefit the whole scenario. All right, over to you, Dhananjay.
I think we are getting towards the end of our discussion, but very quickly, last couple of questions. Ashish, if I can come to you and ask you a question. COCs generally reject plans whose value is below liquidation value, which is based on sort of liquidation value reports. What is your experience of these liquidation valuation reports? Are they hypothetical? Are they accurate? How do you see those go, and how have you seen them play out in the market?
It's a very good question, Dhananjay, and I'm sure there might be some valuation colleagues, professionals who are listening to this. So please don't take this as my very generic view. I have seen multiple reports in under the IBC process across various companies that we have been working on. I would say that certainly, given the importance of the valuation reports, the liquidation valuation reports, and this whole process, it is kind of underplayed, and less importance has been given by the entire, I would say, insolvency professional community to this area. I'm saying, be it the banks, be it IPs, because this this parameter ultimately makes a huge difference on how the lenders decide about a particular plan. And we have often seen the reports are ranging from being highly theoretical, far from reality, or being very conservative in nature, because it just is one is easier to do that. But the problem that lenders then face when this actually comes up for consideration, which is at the at the end after the plan is received, is now how do you deal with it? I've had some pretty interesting conversations with some of the fellow professionals in the valuation trade, wherein I've tried to explain to them how how to look at. I mean, I'm not a valuation professional and I don't consider myself as an expert, but on the ground, sometimes you do get a sense whether there is actually someone willing to buy those products, or that asset or that business at a particular price. So we have seen that we've had to reduce prices, let's say in a liquidation scenario, and often we have also seen that the companies have to actually go towards liquidation, because it's sometimes easier for lenders and the COC members really not to make a decision there. While I know there's a Supreme Court judgment recently which is kind of has indicated that liquidation value should not be the real benchmark or only benchmark to evaluate a plan. But I mean, let's be fair. I mean, there are a group of lenders in the COC who need to make a decision. The number that you're looking at as a comparative is the liquidation value of a report, which is an average of two reports. It sometimes can lead to a wrong decision. But I think it has to be tested more. This has to be put to test more, and I think that's going to happen now.
Okay. So final wrap-up question, and I'm going to pose this to all of you. In fact, it's two questions rolled into one. So both of you, all three of you can take 2 minutes each and tell us two things. One is, how is this COVID and pandemic going to change the IBC process? And second question is, overall, in your experience of IBC, what are the 3 improvements that you would like to see in the months to come? So 2 parts of the question. Why don't we start with Mr. Nair? Sir, I think you're on mute.
You can hear me right now? Okay, so see, major thing, 19, resolution applicants walking through the door and they want to physically verify the assets of the corporate debtor, and that is not something which is happening right now. Now, seeing is believing. So if someone wants to see it and they are not able to see it for whatever reason, because you're going to put in the money on the table, that's going to be pretty distressing for him. And what is the consequence for the lenders? You have fewer number of resolution applicants coming onto the table. So COVID actually on that particular, and the valuations also has suddenly and drastically have gone down for whatever reason, right or wrong. There has been a change in the valuations actually. So what was earlier valued at a particular amount X, now people are coming in and saying that should be X minus 1. So now underlying asset remains the same, the quality remains the same. So these do certainly impact a few of the resolutions which are there. But then if you're asking for whether there would be new additions into this, now that is anybody's guess at this point of time. But at the end of the day, if there is some mechanism wherein where it can be curbed, and government has initiated multiple initiatives to prevent that from happening, and if all stakeholders involve themselves, probably that could be thwarted very efficiently. So that is as far as the COVID is concerned. And the suggestions with regard to the CIRP process is, now multiple government approvals are required to be given. So now what happens is that for a resolution applicant and for the COC also to be involved in that and to seek the government approvals is a very big effort actually. So as part of the resolution plan, if there is a commitment which the government can say that you have to apply for all the approvals, but by default at the end of the 45th day or 50th day, you are deemed to have received these approvals, will actually go a long way. Otherwise, it will be a wild goose chase and it will go on forever. So if there is some finality with regard to these governmental, this is something which should really help actually. And another important point which I would probably suggest is that actually the participation from the foreign stress funds and all that has to be enhanced, and there will be a lot of mechanisms get more of these people involved in the stress asset market in India, and that will actually enable a lot of best practices to come to India, and then you will have a better situation wherein stress assets are turned over very fast and very efficiently. Yeah, over to you.
Before Akash comes in, can I request the audience to start sending your questions using the Q&A box? Once we all finish, we will take up your questions. The Q&A box is now open. You can type in your question and send it to us. Okay, Akash, to you, the same 2 questions. You are on mute, Akash.
Sorry. So on the first question, COVID, right? My view is that say one mirror looking backward and one looking forward. So the good thing is at least so that clarity is now there, that say for the cases which went into default pre-COVID, there is no more.
Akash, we are not able to hear you very well. I think there is some. If you can switch off your video, yeah, keep your video switched off. Maybe there is some instability to the connection.
Sure.
Yes, it is better now. Yes.
So I was saying one reality which has come through. Second, I think
Sorry, Akash, we are having difficulty hearing. Why don't we come
perspective,
back to you, Ashish? Why don't you go?
sure.
Ashish, why don't you go? We'll come to Akash in a minute.
Yeah, sure. So I think while Akash sorts his, I think, connectivity, maybe I can just share a quick couple of views. So I think in terms of COVID, the impact of COVID, to your first question, I think I have seen some huge efficiencies come in. Yes, there are challenges, well, like Mr. Nair mentioned about, how do RAs, how can they, physically inspect assets, etc. Those challenges obviously need to be addressed, but there are also some sort of, silver linings here, because I think there are a lot of efficiencies that have come in. For example, I've conducted, now 4-5 COCs in the last 2.5 months, which have entirely been on, digital medium, where everyone is sitting in their, respective offices or homes. Earlier, this would not have been imagined, that COCs, while there was always a permission to do it, electronically, but the practice was to have a large room that you book and you travel to that room, and that is where the participation in those meetings was lower, because some of the senior personnel from the lenders side were unable to travel, meet the travel commitment time, etc. So I think those have led to a lot of efficiencies, and I hope this will continue even after we get over this pandemic. So a lot of learnings in in the way of doing work. In terms of suggestions for going forward, what can be improved in IBC, there could be several things, but I think I'd like to just broadly mention one or two things. I think one is, if you notice our regulations and our law, it somewhat stops at the point when there is an NCLT approval. There is very little guidance, very little, mention about the next phase, which is the implementation phase of the plan. So once the NCLT approves, from there till the implementation, as an insolvency professional, we have done now 8 or 9 resolutions, which where the implementation has happened, in some cases still ongoing. I think that's another very important area where there are substantial challenges, I think, which needs to be addressed. So if there can be some standardization, some regulations, it will just help guide, just like we have regulations for the liquidation process or the CRP process. I've shared my view, some of my views with our regulator as well, and hopefully this will be becoming into a paper sometime soon. So that's one area which I feel there's a lacuna. And secondly, I think as we were discussing about the importance of valuations earlier, we have found that often by the time you reach a stage of resolution, and given the timelines, the way it has been stretching, these valuation reports sometimes get dated. They are quite old. So there could be some provisions where the lenders should maybe take out, look for some an update on the valuation for a current period, to actually see what is the impact now, because as you all know, that valuation is as on the insolvency commencement date, and even by the time they finish it, it'll be, let's say, 3 months, 4 months, 2 or 3 months into the process, they're required to give the valuation reports. So by the time a resolution plan comes and you're able to make decisions, while in theory it is 180 or 270 days, but actually speaking, in larger cases it takes somewhat longer. So these would be, a couple of my quick suggestions. And there are many other things, but I think in the interest of time, I'll limit myself here.
Okay, Akash, you want to come in?
Yes, so succinctly, I think on COVID, so one worry and hence one imperative which I see is that say naturally because of say COVID, the kind of say backlog which will be there with the NCLT, right? More delay could sort of say come through, right? And hence, say both for the cases which were already there and it goes without saying that say there will be more companies say which say possibly at some point in time will go through IBC say process and hence and in the current context it's I'm not too sure how many companies at least the smaller companies will be able to afford a longish IBC process as is now and hence the imperative to think through the pre which has been much talked about for some time could be very very important and say from uh, say so from the implications of COVID I think that is something that say both from a risk and say what we need to say do so this is what I see. Second, I think so while you've granted all of us say three wishes on what we can change on IBC, if I have to restrict myself to one, just the simplest of the thing, if we can say figure out say way to sort of fast track at least the entry and exit, right? So cases where IBC has been filed, say how quickly the admission happens, right? Because a lot of things also say, depend fundamentally on how quickly the process say starts. In a lot of cases, at that leg, there is a very meaningful lag. Likewise, for the cases where, say, pre-COVID, say there was say 100% approval on the plan from the COC. So we have to see how quickly those can be approved, right? Because in the current context, say naturally 1 month is like 1 year, and the capability as well as say thought process of RA to live through with the old plan may have changed very materially. So I think the speed of that say part is something which is say very critical and as quickly as that can be fixed with more infrastructure, so on and so forth. So that is most vital in my view.
Okay, thank you. I'll take this opportunity to also express my views on this. Number one, I think there are two ways in which COVID is going to change IBC process. One, Ashish has already touched on. I think there will be more reliance on technology. On just now, we are seeing more in terms of meetings and all of that. I remember, Ashish, you will find it funny that I did one presentation in Calcutta and I spoke to insolvency professionals about how you can use technology for insolvency. And there were ideas such as using drones for doing site survey and site visits and things like that. So that was quite interesting. But on a more serious note, I will see more technology coming in. It will sort of help the process. The second thing, which is more on the sort of legal side, is I think the COC will be much more careful on outs, sort of exit routes in the resolution plans. What may have happened in some situation is because of loose drafting or because of specific clauses, some resolution applicant may have considered or even discussing with COC that they want to get out of an approved plan. Now that is definitely something that the COC will look at much more closely. So those are two things in which I think IBC process will change. On the three wishes, I actually have very clear three wishes. First wish is the court infrastructure. I'm so glad that I have Mr. Chandihok listening to it. He has been the flag bearer of improving the infrastructure for NCLAT and NCLT in Delhi and elsewhere. And it's not only to the courtroom and the size of the courtroom, it's also about staff, it's about giving them good training so that the process becomes much more efficient. That is my first wish. My second wish is on adoption of UNCITRAL model law on cross-border insolvency. I think it's very important that we come in. We come in with that and we become at par with rest of the world. The third is I will call it loosely pre-pack, but I don't think pre-pack as we understand in the English market or the US market is possible. So I have actually called it an accelerated fast track scheme in India for distressed borrowers, which will give us sort of a short process for approval of schemes which has already been cooked by the creditors and the borrower, let's say using the 7th June circular. So those are my three wishes, and I'm going to put Mr. Chandihok on the spot, and I'm going to ask him also because we have him here. I'm going to ask him, sir, how is COVID going to change, and what are your I won't call it wishes, but what are your three
So I think no, you're right. Absolutely. I think Ashish was right. The technology is going to play a very big role. It is actually started playing always. In fact, in the entire judicial system today, technology is playing a role. And we are only looking forward to how do we create that infrastructure well. Because if one person got positive in NCALT or something else, and the entire thing had to be closed down. So we need to bring an infrastructure which, and I have been always saying that unless you build an infrastructure first, you must have important people. And I think time has come over 3 years. Now we should look at a cadre who should look at the NCLT and the insolvency regime rather than making rehabilitation process to continue. I mean, I have a strong view that we must have insolvency professionals who are going to man the bench also tomorrow. Maybe little time has come now that we should look at people who have experience at their hand in actually doing Insolvency and Companies Act, that they should come on the bench now and give them that opportunity. And there should be a cadre system from NCLT to go to NCLT, because that is where you are going to give him an incentive to do perform well. That's second part. The third part is that I think we have contributed, each one of us. I mean, let's be all proud of the fact that IBC is one legislation or one code where right from Parliament, Mr. Vishwanathan onward, judges to the Supreme Court has played its role extremely well. We only need to see how the changed circumstances, we should react to the changed circumstances. And in fact, in one of these webinars, a question was put to me, will force majeure clause apply to a insolvency resolution plan only passed? Now the answer is obvious that there can't be. And where will be the jurisdiction to review for the adjudicating authority to review the plan again if it's already started implementation? But however, I find in the last two months, and your experience, all of you would have much more than mine, that many people are coming, notwithstanding there's either insolvency is threatened or in any other contractual situations. They have now started coming to sit down to renegotiate the contract. And I'm sure that time would come, at least those pending resolutions, maybe they are right. All, I mean, Ashish is right. Each one of them is right. It changed circumstances, the valuation may have changed. Everything would have changed. And give you on a lighter note, somebody who had agreed to sell a property at 75 crores has today this morning come and said, if he is ready to pay me 65, I'm ready to sell it out. So therefore, the changed circumstances. Therefore, the changed circumstances would affect our resolution process. It will affect us. But how far suspension of the 6 months would take effect is something to look at. But I'm sure the pending matters, I mean, as Mr. Akash was saying, and Mr. Surya was saying rightly so, let us finish those matters at least the time that we have at our disposal when new matters are not coming. All matters which are pending before the adjudicating authorities for approval must get resolved. And therefore, that will expedite the process and will probably help us to revive the economy. But to end it, my personal view would be I'm looking at that resolution which COC would pass one day and a NCLT or the adjudicating authority would pass, where on a professional acumen of the people who want to manage that business, that is taken, that how will they be able to revive it on a longer term rather than cash flow right in the beginning. That's the day which will really think insolvency will take its real color.
Okay, sir. We will take up the audience Q&A now. We have only one question so far. The question is addressed to Mr. Nair and Mr. Suri. In 2019, banks introduced detailed guidelines on specialized monitoring of stressed account pre-IBC. Can you comment on how useful these have been and why? How monitoring seen as relevant specifically during the COVID moratorium period? Mr. Nair, would you like to answer this?
I did not hear this actually. Okay, what's that?
I will read it out, sir.
There is a question on bad bank. Is it that one or is it the next one?
No, this is a question on detailed
Question
guidelines on.
one is bad bank.
2019 guidelines.
Yes, in 2019, banks introduced detailed guidelines on specialized monitoring of stressed account. Can you comment on how useful these have been and how monitoring is seen as relevant, specifically during COVID moratorium? Either one.
Monitoring has always been a challenge. And sorry, you can hear me?
Yes, yes, yes.
Yes, we can hear you.
Yeah. Monitoring has always been challenge, and the critical aspect of monitoring need no re-emphasis at any point of time, particularly so at this difficult period when actually. So this is an idea which has found now takers, and that will be something which will go to enhance the monitoring mechanism for the banks. Now, there has been multiple circulars which has been issued by the banks and basis the Reserve Bank of India circular. So that process is truly helping the banking institutions as we take this forward. But truly very good out.
The next question is, will the bad bank, this is addressed again to Mr. Nair, will the bad bank ever become a reality in India soon? Why the government is hesitant in investing? Bad bank concept has been a success in certain parts of the world. So what's your opinion?
All right. Okay. Bad bank, typically what bad bank is that it isolates liquidity and high risk assets held by a bank. It's as simple as that actually. And then the provisions, obviously, as you know, the provisions eat into the bank's capital base, resulting in loss of or eroding the depositor confidence actually. So yeah, from that perspective, it is very important that these gets isolated and it is taken forward. But critical part of it is that the capital for this bad bank has to be found out. Now this capital has to come from multiple sources. So I think the Reserve Bank of India, the IBA, and other institutions associated with that are working very hard on that. So we will have to wait out. And critically, we also have to figure out at what transfer price mechanism this loans gets transferred into the bad bank. All those details are probably in the works, and as soon as there is a decision taken by it, it will be announced at the appropriate forum. So kindly wait out for those announcements to come in.
Okay. We can take a couple more questions. One is on.
I'm not able to hear you.
Yes, the next question is on transaction review audit reports. How reports are being followed up by RPs for recovery? No effective recovery till date. Ashish, would you like to answer this?
Yeah, sure. So basically, avoidance transactions, as we all know, the duties of the RP have been, laid out in the law, and basically, it says that the RP is required to determine if there are any such, avoidance transactions under those what we call PUFE transactions, and thereafter make a filing to the NCLT under the relevant sections. Now, the adjudication of those things can take actually much longer, and it depends on, as has been discussed in quite a few times during the course of this session as well, on the infrastructure and the time, when the hearings does come up in the NCLT. So we know that in some of our cases, there have been adjudications, it has been challenged, it has gone up to the next level, etc. It's happening. But yeah, I agree with you. The focus, I think, first is on trying. I've seen that the priority is given for cases which are ongoing and looking at more direct issues related to CRP. But I think I've seen a lot of focus coming from Ministry of Company Affairs on this matter. Periodically, both IBBI and MCA have been reviewing individual cases as to what are the nature of transactions and what has really happened in them, and what are the next steps. So I certainly know that there is a focus there. Have the outcomes, have we seen a lot? Not yet.
Okay. The next question, and I'm happy to take this. What role should ARC be playing in that is not happening so far in order to support resolution of debt and revival of stressed companies? The way I see it, I think what is not happening on the ARC side is the turnaround of asset. I think it's become, it is more of a financial play, and until ARCs are sort of showing more specialized ability to whether it's recover money or turn around asset or support uh, reconstruction of the company, the ARC model will need to sort of work on that. So that's sort of my answer to this. The next question is for Akash. How will the suspension of IBC affect restructuring efforts on ground? What alternate modes do you expect to utilize for resolution going forward?
So, say naturally, say what looks very likely is that as we move forward, say restructuring would become a very important outside IBC. Restructuring will become the dominant sort of say focus for trying to resolve, and that's coming both from the perspective that within IBC there is an eventual say takeout, and the financing is very tough in the currency market. And I think say from that perspective, outside IBC restructuring will become say more and more say dominant. The only issue in few of the cases is that say restructuring naturally is underpinned on the creditors coming together and taking a view, right? In certain cases, say when there is a involvement of multiple other agencies, right? Then outside of IBC, say it is very difficult to say find a solution, right? Because only in IBC, say there is a solution if there is ED attachment or something else, right, which comes in play. And hence, for those kind of cases, I don't think there is say that easy a choice. But say for other operating companies, I strongly think that so some kind of restructuring will be imminent, so given the current times.
Okay, I think we have time for one question only. So the question is there a plan for categorization of resolution professional to handle certain level of transaction? Because all RPs cannot be considered for all transaction. Mr. Nair, Ashish, would you like to attempt an answer to this?
Maybe Mr. Nair can respond to that. I think it's, can you repeat that question, please, Dhananjay?
Yeah. Is there a plan for categorization of resolution professional to handle certain level of transaction, because all RPs cannot be considered for all transactions?
I would say that I know from international experience that individual banks do create certain panels like a ABC category, whereby it makes it easier for them to select and choose the resolution professional quickly, rather than having to go through the entire pool of however many hundreds of RPs who are registered for a particular geography. So they do have panels which make it kind of shortlisted depending on the debt size and the complexity. And but I'm not aware whether there is such a plan for any of the Indian banks to do it yet. But I think certainly would be a good idea to do it. Maybe reduce the effort involved, because I've seen the amount of effort, some of the banks go through in the selection process. The process which, for example, SBI follows, which has now been replicated by several other banks, is quite a tedious process. It's not a simple process. So it might kind of make it easier, but everything is open to challenge.
All right. I think we have run out of time. So I would like to thank all the panelists, Mr. Nair, Akash, Ashish, and my special thanks to Insol India, and my personal thanks to Mr. Chandihok for being here, welcoming us, and inviting us to this event. Thank you, everyone, and to all the participants for attending. Mr. Chandihok, any final thank you words from you? Sir, you are on mute, sir. Mr. Chandihok, you are on mute, sir. No, you are still on mute.
You, Mr. Nair, Ashish, and Mr. Suri for a fascinating session, giving all aspects of the picture that we require. Best of luck and best of times. Please be healthy and safe, you and all.
Thank you.
All of us, and look forward to see you in more participation in Insol India. Thank you so much.